And I think we don't know how a lot of the current members of the court would feel about it. Kavanaugh said some things in his confirmation hearings that I thought broadcast actually some skepticism about U.S. v. Nixon, which, was a unanimous opinion and I think broadly viewed as a correct and important one in terms of this principle that the president isn't above the law, but we don't know if he or really anybody else on the current court agrees with that principle.
Good evening, everyone, and welcome officially to the 8th season of the John Saman Hot Button School Conversation Series, 8th season. I am Mark Sokol. I'm the president and CEO of JCC Greater Boston. This particular season is framed by the following question: where is our country headed? We'll explore polarizing issues that have Americans divided: law, religion, leadership, and our future. Tonight, the future of the Supreme Court. Current court is closely divided, 5 Republican appointees and 4 Democratic ones. Can the court be a non-political institution in such divisive times? Our panel will explore not only the power of the court, but also its limitations, as they examine complex issues this evening facing the Supreme Court and its changing role in our society.
We've already disagreed among ourselves about what kind of role the Supreme Court might have in impeachment, so I think you've got a good panel here. I'm going to start off by sort of laying a little bit of a baseline for folks, just in case you don't follow the Supreme Court as closely as the rest of us do. We know that it's a little bit of a mysterious institution among the 3 branches, and I was joking earlier, it's a dream for a Supreme Court reporter because editors don't understand it at all. And so they really do have to rely on me and what I tell them. So in that way, I like it very much. I thought we would talk about the Supreme Court we have right now. And to me, let's go back to February 13th, 2016. That's the day Justice Scalia died. A huge event for everyone. It would have given President Obama a chance to place a 3rd justice on the Supreme Court. It would have created the first Democratic-nominated majority in decades. Senator Mitch McConnell had other ideas. He said right away that the Republican-led Senate would not consider whoever Obama nominated, saying that the people should decide that November who got to name, they would pick the president who would get to name the next justice. He held the line, refused to hold hearings on President Obama's nominee, Judge Merrick Garland, who Republicans for years had said would be their preferred candidate should a Democratic president get the chance to make a nomination. You might remember that candidate Trump did something that no presidential candidate had ever done, put out a list of his Supreme Court possibilities, and he said that his choice would come from that list. He recognized how important the Supreme Court is as an issue to Republicans, to conservatives, and to evangelical voters. Of those who said the Supreme Court was the most important factor in their vote for president, 56% voted for Trump. According to the poll in the Washington Post, 26% of all Trump voters said that the Supreme Court was the basis of their decision. So Trump picked Neil Gorsuch, a Colorado judge, to fill Scalia's seat. In his short time on the bench, he's proven to be a Scalia 2 in many ways, 2.0. He votes, for instance, much more with Justice Clarence Thomas than with Chief Justice Roberts. And the most dramatic change on the court came last year when Anthony Kennedy announced his retirement. Kennedy, for years, had been the court's man in the middle, the one who was the decider in many of these important cases that split the court. He was replaced by Brett Kavanaugh. You may have heard of those confirmation hearings. Kavanaugh is thought to be on Kennedy's right on most matters, although his first term on the bench did not present many opportunities to judge that. In fact, he seemed determined not to make waves. He supported without fail the Trump administration's major initiatives that came before the court. But on the other hand, he was in the majority of the court's decisions more than any other justice. Now, the most interesting for those of us who watch the court closely is Chief Justice John Roberts. While it's been the Roberts Court since 2005, it became the Roberts Court in fact when Kennedy retired. For the first time since the 1930s, we have a Chief Justice who's also the ideological center of the court. We got a glimpse of how that might work this past term in the court's two most important decisions: whether federal courts have a role in policing state electoral maps for partisan gerrymandering, and whether to allow the Trump administration to put a citizenship question on the census, which experts said could lead to an undercount of immigrants and minorities and one that would harm Democrats. Roberts' answer was no to gerrymandering, and he was joined by his fellow conservatives. He said the federal courts had no role to play. But he also said no to the Trump administration, joined in this case by the court's liberals. He said the administration had not followed the proper rules and had made up an excuse for adding the question that didn't make legal sense. So that's where the court stands right now. Tonight, our panel will talk about where it's going, whether it can retain its nonpartisan legitimacy in a politically polarized climate, and whether it will even remain the Supreme Court that all of us have known for our lifetimes, a court of 9 justices with life tenure. I thought it was interesting last night, Justice Elena Kagan spoke at the University of California at Berkeley, and she addressed the question that we are addressing tonight, one of them. She said, the fact that we live in a polarized world increases the responsibility of the court to behave in a non-polarized fashion. It has to look like a court in order to maintain people's sense of legitimacy in the institution. So let's start off by asking, is the court going to remain the court that we've known for our lifetimes? How seriously should we take proposals by the Democratic presidential candidates and others to add seats to the court or to find a way to limit the tenure of justices? And what are the constitutional problems with those plans? Who would like to go first? You want me to pick?
No,
Okay.
I'm happy to do it. Changing the number is easy because the Constitution only requires that there be one person on the Supreme Court, a Chief Justice. Historically, we've had everything from 5 to 10 inclusive. And there's nothing in the Constitution that says you can't have 3, 26, 42. Oh, Mike? Okay. Nothing in the Constitution limits the number. All you need is a statute. But to say all you need is a statute means you got to have the House vote on it, you got to have the Senate vote on it, you got to have the President sign it. The chances of that happening anytime in the near future, I think, is very small. Changing the tenure requires a constitutional amendment. You would need 3/4 of the states for that. So I think you're going to get a lot of discussion of this, and I actually think it's a good discussion to have. I'm not thrilled with the current structure of the Supreme Court, but the actual prospects of something changing in anyone's lifetime here, I think, is very, very small.
Maybe I'll take a step back and respond to that, to the Kagan observation that it's important that the court retain its bipartisan or nonpartisan legitimacy. So what, just to unpack that a little bit, I think we sometimes do overstate the degree to which the court has historically been totally outside of politics. So within the first 2 decades of the country's history, 1805, just to bring the conversation back to impeachment already, the first and still only Supreme Court justice to be impeached, Samuel Chase, faced impeachment, right? He was impeached by the House, although he was acquitted by the Senate, and went on to serve on the Supreme Court until his death. But one of the reasons he was impeached was well, he ran some trials. At the time, they sat as trial judges, the Supreme Court justices, but he ran a couple of trials in some sort of sketchy ways. But he also was accused of doing politics in a way that was improper for a Supreme Court justice. He had wanted John Adams to win the 1800 election. He hated Jefferson. So the kind of question of how much sort of intermingling of the Supreme Court and politics is not a new one. It has arisen in all kinds of different postures throughout our history. But I think that what the question gets to, and what Kagan's observation yesterday identifies, is that there is something different about the moment that we're in today, and that is that for the first time really in history, you have this perfect alignment in most high-profile and high-salience cases of, forgive me, I'm so sorry, I thought I turned that off. I'll turn it off for real after I finish this thought. Perfect alignment of the policy preferences of the appointing president and the likely votes of the justices appointed by that president. So you have 5 Republican appointees who are likely going to vote in favor of the Trump administration's policy initiatives, and 4 Democratic appointees who are likely going to vote against it. And when that happens, and when the public believes it's going to happen, you do have this potential erosion of legitimacy of the court, right? Why is it important the court is viewed as standing outside of politics? Well, in part because the court has to do things sometimes that are unpopular, and we all have to accept what the court does, even if we disagree with what it does. And that can only happen if we understand the justices are not just politicians in robes, but do something different. So that, I think, is sort of one cut at it. And then in terms of the reform proposals on the table, changing the terms of Supreme Court justices, changing the size of the court, I think all of that is actually useful to have in conversation. It strikes me as tactically a little strange that it is the Democrats who are not in power who are saying, let's pack the Supreme Court, because you have to win the White House and then you have to win the Senate, and in the House, you have to keep the House in order to actually pass legislation that would allow you to do that. And if it were me, and I'm not a political strategist, I would sort of be quiet about that and try to win the elections and then maybe try to pack the courts, because I think I would worry about this asymmetric sort of galvanizing that you could potentially see happen, which is that the other side gets really worried about the future of the Supreme Court and turns out to vote on that basis. But I do think it's a constructive conversation to have. We've had it in the legal academy for a long time, but I think it's very useful that presidential candidates are now talking about it.
Jed, should there really be life tenure? I mean, when this happened, and I believe the United States is the only country that has life tenure for judges, life expectancy was much shorter. They didn't expect people to be spending decades on the Supreme Court. Is this a good idea?
Well, I just want to agree with Gary that whether or not I think it's a good idea, it's in the Constitution. So just to say a word about that, when the Constitution doesn't say life for judges, but it says during good behavior. And this is where I think the text in context is important for understanding the Constitution. Because when they use the phrase tenure during good behavior, everyone understood that to mean for life, except for impeachment for high crimes and misdemeanors. So I want to agree about that. But the other, I think your observation about lifespans being longer cuts against term limits and cuts in favor of life tenure. So let me explain why. The current structure, the current expectations have led presidents to appoint younger and younger justices to the Supreme Court. So now it would be unthinkable, unless you're President Obama trying to get Merrick Garland through. What people remarked on with Merrick Garland was how strange it was to see someone in their 60s get nominated. 50 is basically the expectation, 50 or in the young 50s, to guarantee that you might have 30 years. So that's not going to change. If there are term limits, the proposal is to have each justice have an 18-year term to set up with a 9-justice court, a cycle where every president can expect to appoint 2. The problem, I think, that is bigger than the solution here is that you will still have young justices being appointed to maximize the chance that they're still productive. And if you have a 50-year-old or a 55-year-old getting appointed to the court, the president wants to know that that nominee to the court is going to carry on the ideology they expect. That's more likely if someone is going to be forced to retire at age 65 or 70, that they want to have a sweet gig on whatever news channel lines up with that president, or to get a nice job as a as a commentator. So I think that it's precisely because of judicial independence that we should continue with life tenure. The other thing to say about it is, for those that want to get an immediate payoff by changing the court's composition or ideology, none of the proposals will go through unless they are not sunsetted, but sun-risen. They won't go into effect and won't make a difference for 20 years or so. So I think it's a complete waste of time to talk about term limits. Let me just suggest one other way to think about how to manage the court's politics. I've written about a proposal to require a 2/3 majority of the court to strike down a statute. So I call this a 6-3 rule. There's a line in the Constitution that says that Congress has the power to make regulations and exceptions to the court's jurisdiction. One way to think about jurisdiction is the kinds of questions it has jurisdiction over. So to require a court, because there are so many 5-4 votes, the history that I looked at, it was remarkable how few 5-4 decisions were used to overturn an act of Congress until the last generation, until the Rehnquist court. Basically the idea is this rule would enforce a kind of deference and consensus, at least in some of the most significant political questions we face.
Justice Ginsburg likes to say that she was everybody knew when she was nominated that she was a flaming feminist. Liberal ACLU lawyer, everyone knew how conservative Antonin Scalia was, yet they were overwhelmingly approved by the Senate. Scalia unanimously, I think, Ginsburg almost unanimously. Could a president of one party have his or her nominee confirmed by a Senate controlled by the other party? And if not, how did we get to this point? Kate.
Unfortunately, I think the answer is probably no, probably not any time in the immediate future. I think Merrick Garland...
So you would have to have the White House and the Senate.
Not the House, but the White House and the Senate would need to be controlled by the same party until something pretty dramatically changes, I think, in order to get any Supreme Court justice confirmed. And so I think that means we may have 7- and 8-member courts for, there can be longstanding vacancies unless some of these structural reforms actually do pick up some significant support. So gosh, how do we get to this point, right? So, a lot of people trace the kind of politicization of the confirmation process to the failed nomination of Robert Bork. Arguably, President Lyndon Johnson's effort to elevate Abe Fortas from Associate Justice to Chief Justice, which was unsuccessful, and in part because of some sort of financial misconduct, in part because it came out during the consideration that he had been, while a sitting Supreme Court justice, kind of giving his friend, the president, legal advice, which people thought seemed improper. And so maybe that's, but somewhere in the 1960s to 1980s, the confirmation process sort of, and in part this coincides with the beginning of televising of Senate confirmation hearings. I think that is part of it. I think I should know this offhand. I believe that my former boss, Justice Stevens, who was confirmed in 1975, was the last justice whose hearings were not televised. His hearings lasted maybe 2 hours. He wasn't asked a single question about Roe versus Wade, which had been decided 2 years earlier. He, was confirmed unanimously and sort of took the bench the next week.
And he tells a great story, I have to interject, about when someone was up testifying about what a bad person he was. A senator asked if he wanted to go back to his office and have some bourbon while that went on. And indeed, that's what they did, while this person talked about what a terrible person Stevens was.
I had never heard the story, but I presume it was. There was one sort of organized opposition sort of group, which was a women's group from Chicago, because he had ruled against 1 or 2 discrimination plaintiffs in employment discrimination cases when he was a Court of Appeals judge in Chicago. And so he had a little bit of organized opposition, although not enough to attract any votes against him. And of course, I think he was a great friend to equality and women's rights for his whole time on the bench. But yes, it was a different time in terms of the sort of genteel quality, and sort of there just wasn't, if someone was an accomplished jurist, which he was, and a very respected lawyer, sort of there wasn't a real question of partisanship. And in part, he was selected because he was viewed as an uncontroversial nominee. This was President Ford wanted something sort of low profile and low temperature in 1975. But I think that, unfortunately, we may have passed the point of no return in terms of politics and confirmation process. That's sort of my pessimistic view.
What do you guys think?
Well, I mean, Kate has made, I'm on now, some very, very important points about the history and the very long history of partisanship and the court. There's always a tendency to imagine that you live in the worst of all possible times. How are you doing today? Oy vey, my back hurts so much, and it's gotten so much worse over the last couple, didn't your back hurt 3 years ago? Well, yeah, but it's so much worse now. There is something to the idea that it's always been that way. Is it more extreme now? Well, yeah, if people like Elena Kagan and Brett Kavanaugh can't get confirmed that easily, probably nobody can. But here's the other side of that. About 90% of what the Supreme Court does really is nonpartisan. It's technical, dry, dull stuff that even we can't stand to read, right? It's that bad. And that 90% of the cases that they decide generally get decided without any fireworks. It's done by the technical lawyer's craft. A lot of them are unanimous, near unanimous. It's a very, very small percentage of the actual workload that generates the headlines, the 5-4 disputes. And those are the ones where the partisanship cries ring, and they ring true. And I'm just going to suggest that it's not entirely a matter of the court just being caught up in the wrong times. To some extent, the court has brought this on itself by interjecting itself into every single matter of any consequence anywhere in the country at any level of government. Once you do that, it's a little bit odd then to sit back and say, well, but you can't. So yes, I do think that you're seeing an intensification, but part of it is the court's own doing.
Yeah. Does the court take on things it shouldn't take?
Well, it's also amazing how little the court takes on, right? So the other surprising aspect of the Supreme Court is its discretionary docket keeps getting smaller. So they like their vacations. They want to make sure that they only write opinions on big cases. So on the one hand, I agree with Gary that there's a lot of very narrow technical cases. On the other hand, the ratio over time of how many big political cases they take is actually growing. So this is, I think, a larger problem. This is maybe a question for discussion, is that part of the crisis is just how much more active the Supreme Court is in so many different aspects of our life, whereas Congress is cabined by the Constitution to deal with questions that are enumerated, like the Commerce Clause, for example, and the states have their domain. The one body, and the president also has some limited powers by Congress. The one body that really has no limits as far as it wants to do whatever it wants to do is the Supreme Court. So it's a problem, I think, of judicial supremacy. And so I might also suggest that the one way I can foresee brokering of a compromise might be a centrist body of senators. It only once the Supreme Court is, let's say, down to, by attrition, down to 5 or 4 members, waiting as long as there aren't senates that are in the president's party. I can imagine sooner than that, senators sitting down and saying, we're going to actually decide. We're going to do the confirmation process starting with us and tell the president, these are the 3 or 4 people we'd consider, and then you can pick among these 4. That's actually a lot like what many states do, formally by merit selection. So a plurality of states have a panel, a nonpartisan panel or a bipartisan panel, including experts from the Bar Association and sitting judges, to come up with a consensus list. I think that could be informal, but unlikely as long as we're still trying to calculate which vote will overturn Roe v. Wade versus which vote will preserve it. I think Roe v. Wade is the deal breaker for any confirmation of justices if there's not bipartisan, if there's not single partisan control between a Senate and a president.
We're going to talk about that in a few minutes. I feel like we should talk about, I understand there was some news today. We were also busy preparing for this. We missed it. But as I said, we in the impeachment proceedings, the Supreme Court does not have a formal role. The only formal role is that if there is an impeachment and if there is a trial in the Senate, the Chief Justice has to preside over that trial, although I don't think the Chief Justice actually gets to make a lot of decisions during
the Chief Justice in the Johnson trial actually made a lot of rulings,
okay.
but I don't know if Rehnquist did much in Clinton. I don't think he did very much.
But Jed, do you think that there are other issues that the Supreme Court could be important in as we head down this path?
Well, let me name three, and depending upon how this process goes and how long it takes, but from the outset, I think you're going to have, just with the House impeachment, before you even get to a Senate trial, the House impeachment inquiry is going to issue a number of subpoenas. The biggest one that they're going to start with is seeking not, so Trump announced today that he would release the transcript of his conversation with the Prime Minister of Ukraine. The consensus in the intelligence community is that the transcript is actually not the big deal. Precisely the reason why Trump wants to release it is because he avoided making an explicit quid pro quo. I mean, it's damaging enough what we already know about it. But the issue is that the Inspector General's report reportedly goes beyond the transcript of the phone call and has other supporting information that makes it even more alarming. And that, I think, is the shell game that perhaps President Trump is playing. I'll throw you some meat to distract you with the transcript, but it's really the Inspector General. So first, we're going to have a subpoena over that report. I think the Trump administration will fight it, and then we will have litigation over executive privilege, and that actually is a tough question. I think that's not obvious about whether that could be privileged. Then two other kinds of subpoenas of witnesses. The Democrats have put far too much stock in trying to subpoena Don McGahn. I think McGahn is largely irrelevant. In fact, the counterpoint to McGahn is if Trump really wanted to fire Mueller and he ordered McGahn to do it and McGahn refused, there were a number of other ways. Trump by tweet, I mean, something that Kate knows a lot about is presidential communications. Trump could have found other ways. So the Democrats need to be more careful and more strategic about witnesses, but that'll be a fight. And the final thing is other documents like tax returns. Tomorrow in the Southern District of New York, Trump's lawyers have filed a remarkable complaint basically saying that because a president can't be indicted, nor can a president or the third parties the president interacts with, they can't be subpoenaed and investigated. It's really a 6-word complaint. The president is above the law. Is that 6 words, right? So that will probably go up to the Supreme Court. So I think there will be a lot of litigation on this.
Well, except historically, courts have been very, very reluctant to resolve those kinds of interdepartmental arguments. What they usually do is say something wishy-washy like, well, you go back and narrow your request or answer this. Very, very rare that you actually get a judicial ruling on this. So over the course of, 2+ centuries, how many actual decisions do we have about the scope of presidential privilege or congressional powers of investigation? I can think of 3 off the top of my head in 225 years.
But we've also only had 2 impeachments of a president, and the one that wasn't an impeachment generated the most important one, U.S. versus Nixon. So,
but right. Just the one I'll say is all of the disputes that you're talking about exist whether or not it's under the guise of an impeachment inquiry or not. That is the fact that it's an impeachment inquiry rather than a congressional committee asking for stuff to think about legislation or possible impeachment or whatever doesn't change the legal analysis at all.
It could, though, because so you have these 2 principles that are in some tension. You have this idea that Congress has this oversight power. So Congress does lots of things besides pass laws, and it investigates. And sometimes, like the most serious kind of investigation it does, it investigates in conjunction with considering impeachment, especially if it's considering impeaching a president. And so you have that power that is not explicitly spelled out in the Constitution, but the Supreme Court has recognized. And then you have this executive privilege, this idea that's also not explicitly in the Constitution, but that the Supreme Court has recognized. And it's true that the Supreme Court has not resolved how they interact. You have the U.S. v. Nixon case, but that's not about a congressional inquiry. That's about an executive branch investigator. And the court does very importantly find, in a unanimous opinion, that this generalized need for confidentiality does not overcome this legitimate need for evidence, but it's evidence in the context of a criminal trial of these so Nixon is an unindicted co-conspirator. These are the actually indicted co-conspirators whose trial this is sought in conjunction with, or whose trials these tapes are sought in conjunction with. So those facts are really different. We're not talking about Mueller asking for this IG report. Now we're talking about a congressional committee, and that is very much an unresolved legal question. And I think we don't know how a lot of the current members of the court would feel about it. Kavanaugh said some things in his confirmation hearings that I thought broadcast actually some skepticism about U.S. v. Nixon, which, was a unanimous opinion, and I think broadly viewed as a correct and important one in terms of this principle that the president isn't above the law. But we don't know if he or really anybody else on the current court agrees with that principle.
I think one thing that we will all agree on is that with the replacement of Justice Kennedy by Justice Kavanaugh, we have a court that is more conservative than it was. I think I went to a panel discussion this morning in which we sort of thought with Kavanaugh replacing Kennedy, the court will move to the right, and the question was, how far and how fast, and the answer was not that far and not that fast, at least last term. One of the things that I think is somewhat misunderstood about the Supreme Court is that in some ways it is captive to the cases, the issues that are in front of it. It doesn't just decide, okay, we're gonna just settle this abortion thing this term and get it over with, or we're gonna figure out gun control this year. They wait for specific cases, and sometimes they have cases that present these questions, and sometimes they don't, and sometimes they have them and they don't take the cases because they don't want to decide them. But this year, even in this presidential year, there are a number of really, as we would say, hot button issues, and there are a gun case that's waiting, there is an abortion case that's waiting. There are cases about whether federal law, workplace discrimination laws protect gays or transgender individuals. And so I thought it would be important for us to talk about some of those cases and where the court might be headed on that. At confirmation hearings, if you watch them, you know that it seems like everyone is obsessed with Roe and whether Roe is going to be upheld or overturned. And what we know is that the court's abortion jurisprudence can change drastically even if Roe technically stays in place. And so the court, we think, will have to take at least one abortion case this year that's sort of teed up for its discussion. And so I want to ask you, what is the outlook for abortion rights and restrictions with this new court? And Kate, do you want to start us off on that?
So the court has been 5-4 for some time on matters of abortion in the Constitution. Justice Kennedy was the fifth vote, both to uphold, but more recently to strike down abortion restrictions. The last big Supreme Court case was a 2016 case out of Texas in which Justice Kennedy cast the deciding vote to strike down a Texas law that would have shut down, 3/4 of the clinics in the state of Texas. And so the court, in an opinion by Justice Breyer, struck that down and sort of reaffirmed the core holding of Roe, and then Planned Parenthood versus Casey, another important abortion opinion from about 20 years after Roe. But of course, Justice Kennedy is no longer on the court, and he's been replaced by Justice Kavanaugh. And what little writing Justice Kavanaugh has done suggests he is much more skeptical about the soundness of Roe versus Wade and Planned Parenthood versus Casey than Justice Kennedy was. And so I think that states have noticed this change in composition on the Supreme Court. So you've seen over the course of the last year just a host of new laws passed in the states. Some of them are virtually or actually total bans on abortion, and then there's lots of other kinds of restrictive regulations that aren't bans but make abortion much more difficult to access. None of the bans will be before the Supreme Court anytime very soon. Those are being struck down by lower courts, and I think the Supreme Court will probably just choose not to take up those cases for at least the very near term. But there is one case that the court will consider next week and may announce its decision on then, or very soon thereafter. That's a case out of Louisiana that's just like the Texas case that they decided 3 years ago, but a different state and a different composition of the Supreme Court. And so that law, like the Texas one, basically requires physicians who perform abortions to have admitting privileges at a local hospital, and that sounds totally uncontroversial, but it turns out it's really hard to have it's often very hard to get these admitting privileges because hospitals aren't always like within 30 miles of the clinic, which these laws require, or hospitals say to keep admitting privileges, you have to admit a certain number of patients every year. Early abortion is very safe, so if you don't admit a lot of patients, you lose your privileges. Anyway, so this law would shut down most, if not all of there's like 3 doctors performing abortions in Louisiana right now, and 2 of them for sure would be unable to get these privileges. So the court will have to decide, I think, whether to take this case and then whether it's going to essentially reaffirm what it just did 3 years ago with Justice Kavanaugh playing the role of Justice Kennedy. I think it's pretty clear that the others on the court would not, and there's a question of the Chief Justice as well, Chief Justice Roberts. So those are the 2 whose votes are in real question. And even if it does take up the case, how it decides to grapple with Roe, if it sort of said, and these other opinions, if it decides to say sort of forthrightly, we're going to reconsider whether the Constitution really does protect some kind of abortion right, or whether it says we're not going to touch these settled cases, but it's going to sort of do this chipping away at the edges of Roe. So uphold this Louisiana law, even though it would make abortion almost inaccessible in Louisiana, without saying it was undermining or overturning Roe. And then you have this sort of effect of making abortion very difficult to access without, the sort of political conversation about what it might mean for a court to overturn this longstanding precedent. So that's, I think, the case that's most likely to kind of tee up these questions in the very near term.
Gary, there have been a lot of states, as Kate says, that have passed restrictions that get more and more restrictive, sort of begging for a fight.
Yep.
At the Supreme Court. There have also been states that have passed laws that keep abortion rights in place and would take up the slack in case Roe is overturned. Is that the way it should work?
Well, all right, let me say two things. One, I want to pursue this. I don't want to divert us, but I hope someone asks about this in questions. The swap of Kennedy for Kavanaugh, I think, makes the court less conservative than it was before, but it makes it more what I would call constitutionalist, and that's an important distinction. We'll get to that later. Well, if I was actually any good at predicting the outcome of Supreme Court cases, I would not be a law professor. I would be auctioning off that talent on eBay. So I don't want to get into speculation about what's likely to happen. I'm just trying to imagine John Roberts wanting to be known as the person who presided over the court that overruled Roe. So I don't think that that's likely to happen. I think Kate's right. You're going to get in terms of what the right answer is, and I say this as somebody who is personally pro-choice, for whatever that's worth, no, the Constitution does not restrict state legislatures from regulating abortions. That was all made up. Happens to correspond reasonably well with my own personal policy preferences. But I think it's howling nonsense as a matter of constitutional law. So I guess the short answer would be yes. That is something the Constitution leaves to the states. Would I vote for a constitutional amendment that implemented my own personal Absolutely. But yeah, I think the death by 1,000 cuts is exactly what you've been seeing for 30 years. Because this goes back to 1992. 1992, absolutely everybody was 100% certain, this is the end of Roe, it's all over. No, it didn't happen. Every year for the last 27 years since, this is the time when, no, it just keeps going and going and going. No matter how many times you beat it, it keeps going and going and going. It's just that after you beat it that many times, as Kate says, in some circumstances, there's not much left. That's maybe about a dozen states. What would be the effect of overruling Roe in Massachusetts? 0. What would be the effect in New York or California? 0. In Louisiana, yeah, you'd have to leave the state. I think that's the state of the world.
I want to pick up on that. I agree with everything both of you have said. As I think, Kate, your prediction is, I think, right. And Gary, your prediction, I think I would agree with, or at least the speculation. The question I think that leaves is where you left off, Gary. I think you're right that if you overturned Roe, it wouldn't make a difference in Massachusetts, New York, and California. But I think where Kate was going was to observe that what Roberts and his court were going to prefer is to let people imagine Roe is still good law while doing exactly what Kate said and what Kennedy was the deciding vote. So in whole women health, as Kate mentioned, the court had said that there was an imposition, and it's not an exaggeration to say what Texas tried to do was say that any abortion clinic, they had to make sure that the abortion providers had to be admitted at the major hospital, which was actually turns out to be quite an imposition. I think the tables had to be made of pure gold. Everyone had to be wearing authentic 16th century garb. So, and Kennedy, and there were only 5 votes to say that that was an undue burden. Well, Kennedy's gone. Kavanaugh's on the court. Kavanaugh is more likely to vote with Roberts, not on overturning Roe v. Wade, but to have a farce of Roe v. Wade. Now, I think 2 points. One is, I agree with Gary that the doctrine that's the basis for Roe v. Wade is highly questionable. We in law school, and just a little bit on this, the doctrine that created a right to privacy in the 60s then was the basis for Roe v. Wade on a doctrine called substantive due process. The word substantive is not in the Constitution. And in fact, when we teach law students, we teach them for a year how to separate between substantive questions and procedural questions, with one exception, substantive due process. Some might say that's an oxymoron. So as a matter of doctrine, Roe v. Wade is vulnerable to a critique that it is made-up constitutional law. Now, I would find other places in the Constitution to protect abortion. But I think that taking a step back, Roe v. Wade does not, if you overturn Roe v. Wade, it would not make a difference for the observations that Kate made for what life would be like in Louisiana. Currently, even under the current doctrine, if you live in North Dakota or South Dakota, you have to wait for a doctor to fly in once a month from Minneapolis, and and the timing of when you find out you're pregnant and then getting an appointment with that doctor means that basically you have to think about a coat hanger anyway, right? That is the reality in America today, before Kavanaugh replaced Kennedy. So the question I just have to ask is Roe v. Wade as a name on the books worth the trade-off we make in politics that gets Donald Trump elected? Because that is more mobilizing to the evangelicals who hold their nose and vote for the person who's going to appoint a Gorsuch and a Kavanaugh, and also defund access to women's health. I would rather have Roe v. Wade formally off the books, doesn't make a big difference in America today, but have voters more likely to go to the polls, evangelical or secular, and vote for more health care. And that makes a bigger difference for women's health.
Well, let me ask about another issue that's not at all controversial, gun control. For the first time in 10 years, the court has accepted a case that challenges restrictions on guns. This is a New York case about the transport of handguns for someone who has a permit to keep a gun in their home. Now, there are some problems with this case that means that the court might declare it moot before it does, but the importance was that with Kennedy gone, with Kavanaugh on, the court accepted a Second Amendment case. And as I say, they haven't done that for a decade now. And so Justice Clarence Thomas has complained that the court treats the Second Amendment like a second-class right. He seems to have some support now with the new justices, Gorsuch and Kavanaugh. And so where do you think we go from here on gun control?
Well, actually, I think it's a beautiful lead-in from where we were, because I think you're seeing much the same phenomenon of cutting back, not done by the Supreme Court, but done by lower courts. It was more than a decade ago, 2008, that the Supreme Court first essentially put the Second Amendment into the picture, and then 2 years later incorporated it against the states. And what has happened in those 10 years? Gun owners free to do whatever they want? No, you've got the restriction on this, and you can't carry it there, and you have to carry it there. Not overruling the Supreme Court's decision outright, but you chip away at it here, you chip away at it there. So I think it's very much analogous to what you've seen over the last 45 years in the abortion context, where there's the recognized constitutional right, but legislatures, lower courts, chip away at it here, chip away at it there. So I think Clarence Thomas was right. The interesting thing is not that they're taking a case now, but that it took them 10 years to decide they wanted to do it. But having said that, I don't think this case is likely to go anywhere for a technical reason that bores even law students. It's not actually going to get decided.
Does anyone want to say?
Maybe just one more beat on that. Yeah, I mean, I would disagree a little bit with the chipping away description. I mean, it's not that states saw the Supreme Court in 2008 protect an individual gun right under the Constitution and rushed to pass laws that were inconsistent with that. These laws were mostly already on the books. Yeah. And so states have always done some states have done a lot. Many states, particularly in the West and the South, have done very little. Dense cities like New York and DC and Chicago and Boston have always done a good amount to regulate guns inside city limits. And so there's always been kind of a range. And so, but what you've seen since 2008 is all of a sudden this emboldened opposition to laws that restrict gun use or gun ownership. And I think it's definitely right that most of the challenges to those laws have been unsuccessful because the lower courts have read what the Supreme Court did in 2008 pretty narrowly, because what the Supreme Court did in 2008 was to strike down a total ban on handguns in the District of Columbia, but to leave pretty open how other gun regulations would be scrutinized. And I think it's right that the court might be poised, probably not in the New York case, but in some other case in the next year or two, to write an opinion that takes the Heller case from 2008 and applies it to carrying guns outside the home or to invalidating restrictions on the kinds of guns you can own at all beyond just handguns. And so and I think there's an interesting phenomenon that goes a little bit back, or a potentially interesting dynamic that goes back to the opening framing, which is that the kind of court and sort of politics and public opinion. So Linda Greenhouse, who writes for the New York Times still as a columnist, has written a couple of interesting columns about this, and she thinks there may be, so the court is now for the first time in a decade and kind of ever maybe poised to decide some cases that are really sort of vindicate the rights of gun owners and undermine kind of gun safety advocates' policy preferences. And the public is moving the opposite direction, actually, right? You actually have increasing support in light of some of these horrific mass shootings for increasing gun regulation. And that's a disconnect that, so we could really see some tension. There's a beautiful brief actually filed in the New York case by some Parkland survivor, some kids who, teenagers don't typically file Supreme Court amicus briefs, and they file one, and there's obviously been a mobilization that a lot of those students have been responsible for, so you have sort of popular sentiment that's really starting to shift when it comes to guns, but the Supreme Court, I think, is maybe moving in exactly the opposite direction.
Let me get to another issue. Right off the bat, on the second day of the term, the court is going to be hearing some cases that talk about federal anti-discrimination laws in the workplace, particularly a law that was written in 1964 protecting workers from race discrimination and discrimination on the basis of sex. And the question before the court now is, does that, because of sex language, also cover sexual orientation? And does it cover transgender workers? There are 3 cases, in 2 of which the folks claim that they were fired because their employers found out that they were gay. In the other, the person, I think everyone agrees, was fired because he had worked as a man at the funeral home, announced that he was transgender and would come back to work as a woman after vacation, and was fired before that could happen. And so it's a very, I think everyone would agree that this is not what Congress had in mind in 1964 when it wrote this law. But is that enough, or do you look at what the text of the federal statute says and base the decision on that? So who would like to start us off?
Well, I mean, just so everyone's clear, nothing in any of these cases has anything to do with the United States Constitution. What they're doing is interpreting a statute. And while it may seem like there is a lot of similarity between interpreting constitutions and interpreting statutes, because they're both texts, and it's possible to argue that they should be exactly the same, as a matter of actual practice, they're not. What is the accepted method in the federal court system for interpreting statutes? I have to teach this stuff to my students. And the answer I give them is there isn't one. And if you go back 1,000 years in Anglo-American legal history, there's never been one. There's never been a consensus, uniform approach exactly to how you go about interpreting statutes. Everybody agrees that there are certain things you're supposed to look at. Nobody agrees necessarily on what order you're supposed to look at them on. In one of the cases that I've just mentioned, the one in the Seventh Circuit Court of Appeals, I believe there were 4 separate opinions giving 4 completely different reasons why different judges thought the case should come out the same way. That is, they all reached the same result, but I believe it was 4 different reasons why. So you want to call this one? Go, give it a try. I have no idea what they're going to do with this stuff.
What I think is interesting about the way that those courts decided it was a surprising number of Republican judges, including a judge you know well, Kate.
So Judge Posner of the Seventh Circuit has a fascinating and sort of idiosyncratic opinion in this Hively case, which is the one that Gary was just talking about. But lots of Republican appointees have come to the same conclusion that the prohibition on discrimination because of sex doesn't just mean biological sex, it includes the sex of your romantic partners, right, or sexual orientation, right? So, and he very clearly says in 1964, when I was in college, nobody thought this law would have applied to sexual orientation. But guess what? He sort of says times change, and so we should change the meaning of the statute. Most judges don't quite say that so explicitly, but yeah, sorry, so please go on.
Oh, no,
yeah.
So I think that sets up this question really well, which is, and so Gary touched on how do you interpret statutes? We interpret statutes differently than we do constitutional text. I completely agree. And Kate made this observation about, well, statutes meaning changes. So just to say a little bit more about how we interpret statutes, I'd say there are 3 kinds of modes. I'm oversimplifying a bit, but there's text, and ever since Scalia put the emphasis on text, that's really taken hold really across the spectrum. The text is the starting point. Then there's also legislative history to look at what the expectations were and the motivations were narrowly of the members of Congress. And then lastly, there are broader purposes, which is different from legislative history. Now, the 1964 Civil Rights Act was initially put forward in Congress to be about race. And the story, it's a little complicated, but a story that's told about that Civil Rights Act was it was a Southern member of the House that stuck the language of sex into the statute as a poison pill, thinking there's no way, race is one thing, but there's no way all these, high and mighty self-righteous Northerners are going to vote to make sex equality. Well, guess what those self-righteous Northerners and Westerners did? They said, we'll take the race and we'll adopt your protection of sex. So even looking at legislative history isn't that helpful. So what I think is interesting is purposes, right? So the text talks about sex. That means, I think, that ironically, it's more likely of the LGBTQ that the T is closer to sex. Because discriminating on the basis of sex is exactly what it is to discriminate against someone who's transgender. Because their identity is about their sex. Now, it turns out sexual orientation is not discriminating based on one's sex identity. It's about who they love. That's different, whom they love, sorry. So that's different question textually. So I would actually say that the most important feature of this aspect of interpretation are the broader purposes. The purposes of the 1964 Civil Rights Act were to extend equality to those who are marginalized. And even if they didn't expect it to apply in this limited way, I think that you can interpret the word sex to not only apply to transgender, but to take it seriously, also apply it for sexual orientation. My prediction will be that, that the court might be more likely to recognize transgender, but I would be surprised if this court goes to sexual orientation.
But don't you think that these cases are going to come down the same way? I mean, you really think that they're going to say a transgender person is protected by the law, a gay person is not?
Yeah, that's not implausible. I mean, it may or may not happen, but it's not at all implausible for exactly the reasons that Jed gave. It's extremely difficult for all sorts of reasons to argue that this particular 1964 statute covers discrimination based on sexual orientation, provided that the person doing the discriminating discriminates against gays and lesbians both. No, it's true. This is happening. And the parties arguing in the case concede that if you're discriminating against gays but not lesbians, that's prohibited by the statute. But as long as you're discriminating against both, that's not what the statute is about.
And that's what the Trump, yeah.
But the argument about discrimination based on sex introduces a fourth element in this messy world of statutory interpretation. And this is true, by the way, of constitutional cases. And when we talk about statutes, we talk about the Constitution. Almost no cases that get decided in the modern world are actually about either statutes or the Constitution. They're almost all about what prior Supreme Court decisions mean. Almost always. Heller in 2008 was one of the very, very rare cases where the court didn't have a lot of prior decisions, so it actually was trying to figure out what the Constitution meant. Almost never does that happen. So you've got 55 years of case law under this 1964 statute, and at least one of those other decisions that's before the Supreme Court turned not really on any of the things that Jed was talking about, but on how to understand a prior Supreme Court decision that tried to figure out, well, what happens if you're sex stereotyping? When does sex stereotyping actually amount to discrimination based on sex? And I think the case is likely to turn on that more than anything else. So anyway, this is, again, I warn my students day one when they have to deal with this stuff not to get their expectations very high.
Lawyers love hypotheticals, and this case is great for hypotheticals. I've been to so many discussions about it, and you know, we spent 10 minutes on a bisexual, last week. What if someone is dating, a woman is dating a man, but then she changes her mind, dates a woman, she could be fired for one, not fired for the other. They're great, but we're not going to go into all of those. I'm going to ask them to talk about something that's a little more esoteric and a little more challenging, so think hard about this. And that is that Trump's former White House counsel, Don McGahn, when he talked about the most important factor that the Trump administration was looking for in judges and justices was that they wanted to find people who were determined to rein in what is called the administrative state. And this is something that lawyers and people in government talk about a lot. Most of us do not. But it can be extremely important for how government operates and what your life is like. And so I'm going to get Gary to start us off on what do we mean when we talk about the administrative state, and what is it that they want these new judges to do?
Yeah, well, you're hearing from a decided partisan in this, because I have spent most of my 30 years in the academy on exactly that question. Who are the people in the academy who are most associated with the attack on the administrative state? I'll make the top three. I won't say that I'm number one. I'll make the top three. What's the problem with it? Well, you know, the civics book model of government is you've got a legislature that makes laws, you've got an executive that implements laws, you've got courts that decide cases. And if you actually sit down, I don't recommend this, it's really boring, and read the Constitution, virtually, has very few high flowery phrases. Most of it is telling you how you get those people in those different institutions in and out of government. Here's what this institution can do, here's what this institution can do, here's what this institution can do, and here's how you pick the people to do those things. That is not at all how modern government works. It's certainly not how it's worked for most of the last century, and how far back you want to go is a matter of some dispute. Virtually all of the things that function as laws do not come from Congress. They come from bureaucrats. Virtually all of the cases that are decided are not decided by courts. They're decided by bureaucrats. In everything except pure criminal matters, the amount of stuff that is decided as cases by bureaucrats just swamps by orders of magnitude all of the work of all of the court systems in the United States put together. That's what we mean by the administrative state, that the actual things that run how people live are not decided by the legislatures. Their cases are not decided by courts. Their fates are held by appointed bureaucrats. And that's just not what executives are supposed to do. Jed and I actually agree on this. Executives are pretty limited folks. The Declaration of Independence was screaming about King George this and King George that and King George the other thing and all the horrible things that King George was doing. It created an executive to implement the laws and said, you darn well better implement them or else. Take care that the laws be faithfully executed, something that Jed and two co-authors have a terrific article on. So that's the derangement of modern government. And the thing that I've been tilting at windmills for 30 years, all of a sudden I got a White House counsel who agrees with me? Hey, that's really cool, okay? And to say that you're looking for judges who are out to rein in the administrative state is really nothing more than saying, I don't think, that you're looking for judges who actually take the structure of the Constitution seriously. And for some of us, that structure, that boring stuff that nobody can stand to read, that's the stuff that really matters, because that's what tells you what the institutions can do and how you get them. So that's the partisan take on all of this.
So, Kay, tell me if I'm wrong, but I would say that you're part of an administration that would call those bureaucrats experts.
Sure, yeah, so Gary's, and I will say, if anything, Gary has understated his impact, I think, on the field. If the administrative state is deconstructed, which it could be, like he made the blueprints for that. So yeah, that's, I mean, and I, as you're describing bureaucrats doing all the things they absolutely do, I'm just not sure why that's such a problem. And I'm not sure what the alternative is, maybe more importantly. So if Congress, and only Congress, can make the kinds of policy calls that are required in deciding how many units of particulate matter of different kinds of pollutants can safely be emitted into the air, or what kinds of storage facilities nuclear waste has to be, housed within when it's buried underground in Nevada, or anything else that this complex economy and society that we dwell in requires government to do all the time. Congress can't do all that. It just can't. It has no capacity, it has no expertise, it has no interest. And I guess I'm sure it is the case that there are excesses on the margins and places where administrative power should be curtailed. But I don't think Congress doing all of this itself is a viable alternative. Now, I think Gary would probably say, and again, he really is an expert, so this is a little bit treacherous even to sort of try to tangle on this, but I'm going to. I think you would say that Congress just has to do a much better job giving the tasks to bureaucrats and they can execute this stuff, but I don't think they could do that in the level of detail required to satisfy this very formalistic conception of what Congress is supposed to do and what sort of minimal functionary kind of execution agency officials are able to do. So I just think that however accurate a characterization of the kind of the pristine sort of vision of the Constitution, or of a society that the Constitution represents, that may be, I don't think it squares in any realistic or meaningful way with the world in which we live. But I do think that it's right that that at least the two newest members of the court, and particularly Justice Gorsuch, is really interested in writing into law some of these intellectual moves that would really limit the ability of federal agencies to do much of what they do today: pass regulations, interpret their own regulations, and any number of other things. So that's my initial response.
Jed, when the Supreme Court had a case touching on this last year, Justice Breyer said, why should judges? We should rely on the experts in the agencies. We certainly don't understand this stuff. What's wrong with that?
Well, I want to say three things about this. I mean, first of all, when Gary mentioned my book, he violated, I really wanted to be the one to plug Gary's book. Gary wrote this terrific book called A Great Power of Attorney, and it, I think, reflected a fiduciary sense of government, of obligations and fiduciary limits. And so I was picking up on this school of thought when I and other co-authors.
Okay, buy their books.
And second thing is that I can't go without mentioning that Kate has a terrific new podcast group. So everyone, out of balance here, we're fair and balanced.
I'm going to tell you how to subscribe to the Washington Post before this meeting.
So it's at strict scrutiny, and it is designed for a lay audience to unpack, among other things, court packing and other complicated concepts to demystify them. But what I want to just emphasize is the notion that the Constitution does set up a difference of what each branch is supposed to do. So let me give you an example in the last term about this problem of delegating too much authority to the executive branch, because one thing we have to worry about is delegating too much control to prosecutors. I mean, the most powerful person in our government isn't really the president. I mean, the president is checked by robust elections in the media and the courts and Congress. The most powerful person in our system is the prosecutor, who makes life and death decisions, sometimes literally life and death decisions, and our statutes give those prosecutors way too much discretion. So it's not just prosecutors, it's not just bureaucrats, it's all kinds of people who wield tremendous power over us. So the Supreme Court, in a decision called Gundy, looked at the design of the sex offender registry. And Congress couldn't make up its mind about an issue that affected about 1 million people, or 400,000 people. Should it apply retroactively, or should it apply going forward? That sounds like a technical detail, but it's the kind of detail that affects so many people that our elected officials should be in the position to make that choice. And instead, they left it to prosecutor. They left it to the Department of Justice to come up with that. That's an example that happens all the time, because Congress decides that it will not decide. Because Congress is too broken or cowardly to make tough choices, they delegate it to unelected bureaucrats, and some of whom have too much power already. I'm thinking about prosecutors. So I believe that it's important for this court, with Gorsuch and Kavanaugh, to make this difference, to limit the power of the executive branch and to tell Congress to do its job.
Another subject, I recently went to another one of these Supreme Court previews, and a leader of a conservative religious group said that this could be the biggest term in years for his organization if the court accepts some of the cases that are out there, depending on what it does on some of the cases it's already done. Last term, the court voted 7-2 to allow a massive cross erected more than 90 years ago to honor World War I dead continue to stand on public land, even though lower courts had found that that was a government endorsement of religion. This term, it'll hear a case about tax credits for funding religious schools. And some of the conservative justices have expressed doubts about some of the court's rulings in the past drawing too strict a line between church and state. Is this a place where the new Supreme Court is going to be much different from the old Supreme Court?
Well, I mean, there are people who spend their lives studying that one tiny little segment of constitutional law. I don't think any of the three of us fall into that category. All I will say is that's one of those things I mentioned earlier where the court stuck its nose in, where it really doesn't have any business sticking its nose in. So they got themselves into this mess. They can get themselves out of it.
Yeah, I don't have tons more to say except that this case from last term, it was interesting. Both, it's the court allows this cross to stand on public land. It's this massive looming cross, but it's been around for 100 years, and it's a pretty fact-specific decision that relies in part on how long this cross has been there. I don't think you can take this opinion if you're a municipality and build a new cross in your town square. So I think it's a pretty limited opinion in terms of its impact outside of this particular dispute. But the 7-2 is interesting, just in terms of complicating the sort of 5-4 narrative that we've returned to a couple of times. So both Kagan and Breyer, in part, joined the opinion upholding that cross, and they did the same thing in this case that is sort of partly about this case, but partly about this sort of the sexual orientation discrimination that we just talked about in this case that the court will hear argued in 2 weeks. That was this dispute, Masterpiece Cake Shop dispute between a baker who refused to bake a cake for a same-sex couple's wedding, or it was a ceremony, they'd been married previously. And the court avoided this big decision that sort of resolved the tension between these two important competing principles, religious liberty on the one hand, equality in the public sphere on the other hand, and sort of said, well, this case is a little peculiar because the Colorado commissioners deciding the dispute in the state said some things that seemed to reflect anti-religious bias, and so they sent the case back without resolving this kind of big clash of principles. But they sided with the baker, and Kagan and Breyer joined that opinion, siding with the baker. And it is, the 5-4 divide is an important one on the court, but also on both the left and the right, with Roberts right smack in the middle. There are different camps, and I do think that Kagan and Breyer have voted together a decent amount, while Ginsburg and Sotomayor are sort of very much the left flank of the court right now. And Kagan and Breyer seem okay with, I think, more sort of solicitude for religion in the public sphere and sort of and protection of religion, even as against other kinds of principles, than the other liberals do. And so I can see actually quite a few 7-2 decisions in this area going forward. So, yeah.
I agree with everything you both have said. There's another case about two cases about religion that were remarkable. People didn't really focus on very much. In fact, it was on the podcast. The Strict Scrutiny podcast talked about these two cases. There was a black inmate scheduled for execution who wanted a Muslim cleric to come and give him his last rites. So, I'm not getting
Imam.
Imam.
Yeah.
Thank you. An imam to come and give, and the court ruled 5-4 by sort of inventing a procedural reason to deny him this basic right. But then when I believe a white prisoner scheduled for execution wanted a Buddhist to come, Kavanaugh flipped his vote, and it was, I believe, 5-4. That is a religion case, and it is very troubling. And it is in tension with, I think, there was a glimmer of hope from Kavanaugh, because in another 5-4 decision, he ruled in favor, and it's shocking that it was 5-4, when a man who was tried about half a dozen times, there was evidence that the prosecutors had struck the black jurors, and the evidence was glaring that this was intentional, and yet it still took only got 5 votes to recognize that this is racial discrimination. So it's too soon to know about Kavanaugh. If you want to be optimistic, look at that jury case on race. If you want to be pessimistic, look at how he so quickly ignored a black prisoner's basic religious freedom before he was put to death.
Well, there's probably a little more to unpack there. I mean, there was some thought that one was filed too late. The court came back and wrote all sorts of opinions about why they did it in a very strange way, weeks after the guy was executed, basically, to try to explain their reasoning. But it raises something that one of these questions is about, and that is sometimes the court makes quick decisions, especially in death penalty cases. They have to decide something right away. There's not full briefing. They don't really explain their answers. And the question we have from the audience is, I think, a little bit related to that, and that has been the propensity of the Trump administration to take cases quickly to the Supreme Court. That instead of letting it go through the normal appeal process, when it gets a bad decision from a lower court, it goes straight to the court. And does that change the view of the court as a political body when it seems like the Trump administration thinks we've got a friend there who's going to vote our way?
Well, the variable in all of this is something that might actually come before the court sometime in the next few years. It's not really there yet, but a couple of justices have opined on it. And that is something called a nationwide injunction. Cases start in district courts, and there are 94 judicial districts scattered all through the United States. And there are judges, sometimes more than one trial judge in each of those districts. So you got to file your case somewhere. Well, okay, suppose a judge in that district, let's say a district in Southern California, rules a certain way. Who is bound by that order? Well, presumably the judge's only jurisdiction is over the people in the territory in which the judge is set up. That's why you got 93 other districts somewhere. What judges have taken to doing more and more in recent years is issuing orders that don't just apply to the territory that they are in, but purport to apply throughout the country. So a judge in California saying, well, this applies not just here, but also in Wyoming and in Michigan and New York and in Florida. In those circumstances, if you then go through the normal review process, you're not just forbidden while the injunction is in force from enforcing your policy in that one area in Southern California, you're forbidden from doing it anywhere in the country. So I think that's why they tend to be going straight to the Supreme Court. If the district judges were just issuing injunctions within their own districts, I think you would see a lot less of that.
Well, maybe. But let me push back on that a little bit. The last two cases were not that. There were cases on asylum rules and on taking money from Defense Department projects and using them for border wall construction that were not nationwide injunctions, and yet the administration went quickly. The court, 5-4, in both cases, approved them. So,
yeah, I mean, the numbers definitely have been quite high in terms of leapfrogging over the courts of appeals and going directly to the Supreme Court. So the Solicitor General under the Trump administration has made 20 of these requests, I think, 20 applications for these kinds of stays, 10 just during the last term alone. And so there's a very good new article by Steve Vladeck. During the 16 years of the George W. Bush and Obama administrations, the Solicitor General filed 8 such applications, so 20 in 3 years compared to 8 in 16 years. So there's definitely been a very significant uptick. Now, Gary offers one possible explanation, which is that district court judges are issuing more nationwide injunctions. I think that is true. If you take another step back, one reason district court judges may be issuing more nationwide injunctions is because the administration is engaging in more flagrantly lawless conduct. And so, I think that there are multiple plausible causal stories, but it is definitely the case that it is, and by the way, these are not just Democratic judges enjoining Trump policies, right? There's been a real mix in terms of the partisanship of the judges issuing these nationwide injunctions, although there is this kind of partisan valence to the debate right now. But I do think it contributes to this perception that when the Trump administration loses in the lower courts and then tries to race right to the Supreme Court and then gets a 5-4, all the Republican appointees allowing allowing them to put into effect some of these policies, it certainly contributes to a perception that the court is just an extension of the political process.
Jed, do you have anything you want to say?
Let's get more questions. That was
well, we don't have time for more questions. Oh. But what we do, or do we? Okay.
We blabbed that much? I'm sorry.
We have time for one more. And, well, this is related. And I'll just read you the question. You guys can react the way you want. Doesn't the Supreme Court as an institution, as the third branch of government, have an interest in preserving its power by saying that the president is not above the law? And if he's above the law, isn't he then above the Supreme Court?
Yes.
Yes, and we should just
absolutely
end there. Yes.
But just one more sentence on that. One concern I have is that I think that it's possible that the Trump controversies over subpoenas will give Roberts and Kavanaugh, et cetera, an opportunity to show that they are impartial by ruling against the Trump administration. And then they will do things like what Kate mentioned, which is then under the radar whittling away at Roe v. Wade. I mean, want to put that out there as the Supreme Court acting like using its political capital in a certain way.
Okay, I'm going to do one more real fast. Do you think we'll ever again see justices who are not from Harvard or Yale?
God, I hope
so, yeah.
I so hope so. I mean,
it's not so bad. Here's the thing that I think we're missing with. I think we should increase the size of the court, but not for ideological reasons driven. The reason why we need more justices on the court is because we have too many lawyers, right? That's the problem. We have too many appellate lawyers who've never practiced, who've never really practiced, who've never really been out in the world. They're not. We have people who need to be. We have economics. We have science. I mean, science. Heaven forbid we have scientists who are thinking about intellectual property, et cetera. The problem is that we don't have a Supreme Court that reflects the world, and I think the Yale-Harvard thing is only a slice, and there's a deeper problem.
I'm going to comment on this one because people ask me about this all the time, and I say that Clarence Thomas and Sonia Sotomayor came from Yale. So I don't think there's a such thing as a Yale justice on the Supreme Court, or if there is, Yale's done a bad job of putting them out there. The other question is always about, could a non-lawyer be on the Supreme Court? And of course, there's no requirement that the person be on the court, but I always think of what Justice Scalia used to say about that, which was, with the number of boring ERISA cases we have to hear, only a lawyer would sit through those. So please thank the panel for tonight.
That's the 90% of the dry, boring, technical cases.